At the outset, the trial chamber notes that none of the perpetrators of murder and cruel treatment known by name or nickname, such as Kemo or Mirki or Beli, were identified to be members of the Srebrenica military police. Nevertheless, based on the evidence given by Nedred Mujkanović, Becir Bogilović, as well as on documentary evidence, including the 2001 suspect interview of the accused with the Office of the Prosecutor, the trial chamber finds that both groups of Serb prisoners detained at the Srebrenica Police Station and the building between September 1992 and March 1993 were kept under the responsibility of the Srebrenica military police. From the very moment it detained prisoners, the Srebrenica military police assumed all duties and responsibilities under international law relating to the treatment of prisoners in time of conflict. Yet the evidence demonstrates that Mirzet Halilović, the commander of the military police until 22 November 1992, did not exercise adequate supervision of the detention facility or the activities of the guards while carrying out their duties. To the contrary, Mirzet Halilović even contributed to the cruel treatment of the Serb detainees. The replacement of Mirzet Halilović with Atif Kirdzic on 22 November 1992 did not benefit the detainees. Not one person or document refers to his presence in either of the two buildings where the prisoners were kept. In addition, during his term as commander, more murders and more cruel treatment took place. For all the reasons stated in the judgment, the trial chamber is satisfied that the Srebrenica military police, through its commanders Mirzet Halilović and Atif Kirdzic, is responsible for the injuries inflicted on the victims. The trial chamber is further satisfied that the accused exercised effective control over the military police, but only as of the 22nd November 1992. Whereas prior to this date, there is no evidence as to how, if at all, the Srebrenica armed forces and the accused exercised effective control over the military police, it is clear that an attempt aimed at restructuring and improving its performance was made in October and November 1992, such as with the replacement of Mirzet Halilović by Atif Kirdzic. Documentary evidence shows that the new military police commander reported to Osman Osmanović, the chief of staff of the Srebrenica armed forces, who reported to the accused. Moreover, in January and February 1993, Hamet Salihović appears to have interrogated a number of Serb detainees on behalf of the armed forces staff. Based on the evidence given by witnesses Neđeljko Radić and Slavoljub Dzikić, as well as on the suspect interview of the accused himself, the trial chamber is further satisfied that the accused visited the Srebrenica Police Station between 24 September and 16 October 1992 on at least 2 occasions, that he had actual knowledge of the death of Dragutin Kukić and of the cruel treatment of the Serbs detained there at the time. However, having found that the accused did not have effective control over the military police during that period, this knowledge becomes relevant only for the purpose of establishing his actual or imputed knowledge of the subsequent murders and cruel treatment. As explained in the judgment, the trial chamber has not found sufficiently reliable evidence that the accused ever visited either of the 2 detention facilities between December 1992 and March 1993, when the second group of Serb prisoners were held there. Although the accused was aware that Serbs were detained in Srebrenica, there is no evidence that anyone kept him informed about their condition. Nonetheless, since the accused was aware that incidents of murder and cruel treatment had previously occurred, the trial chamber finds that he was put on notice that the security and well-being of all Serbs detained henceforth in Srebrenica was at risk, and that this issue needed to be adequately addressed and monitored. The accused also knew that the severe malnutrition and psychological effects of being under siege had severely affected the judgment of people in Srebrenica, several of whom behaved erratically. For the reasons explained in detail in the judgment, the trial chamber finds that the accused had reason to know about acts of murder and cruel treatment committed at the Srebrenica Police Station and the building between 27 December 1992 and 20th March 1993. However, the security and well-being of Serb prisoners disappear from the accused's agenda after an investigation into the alleged killing of a prisoner by Mirzet Halilovic and his eventual replacement with Atif Kirsic. In his 2001 interview with the Office of the Prosecutor, the accused is reported as stating that because of the deteriorating military situation, the detention of prisoners was not on his mind, as there were others responsible for it. The trial chamber holds that, as a general rule, the treatment of prisoners in armed conflict, including their physical and mental integrity, cannot be relegated to a position of importance inferior to other considerations, military or otherwise, however important they may be. This general rule is, of course, predicated on the assumption that at all times the person entrusted with this responsibility is in a position to fulfill this obligation. It does not and cannot apply where there is the impossibility to act or when it would be utterly unreasonable to expect one to act, as in the case of a life-threatening situation. In this case, the trial chamber is dealing with the responsibility of a commander who could discharge such responsibilities by delegating part of them to a subordinate and inquiring from time to time, and in the absence of reports, to at least require them in whatever format. What is unacceptable for the trial chamber is that commanders who, like the accused, positively know that detainees have been exposed to murder and cruel treatment are discharged from their said obligations to protect prisoners under international law by merely delegating the responsibilities in that regard to subordinates without further inquiries. In the present case, the evidence is unequivocal. The accused never inquired about the fate of the Serb prisoners kept at the two detention facilities in Srebrenica from the day Atif Kirsic was appointed commander of the Srebrenica military police in lieu of Mirzet Halilovic. In addition, he expressed and explained his lack of further involvement on the basis of his military commitments elsewhere, and that there were others in charge of prisoners. Regarding the accused's failure to prevent or punish these crimes, the trial chamber rejects the defense submission that no measures could have been taken due to the lack of adequate means in Srebrenica at the time. The replacement of Mirzet Halilovic and the investigation of his alleged killing of a Serb prisoner shows that this could be achieved, even in the absence of sophisticated structures and well-trained personnel. With respect to the...
Kad je riječ o dužnosti,
Is it all right? Is it fixed now? It seems to be fixed, yes. With respect to the duty to prevent crimes of subordinates, the trial chamber acknowledges that the accused operated under most adverse circumstances and not in a properly structured army with adequate means of communication between superiors and subordinates. Still, as of September or October 1992, he had been on notice that the Serb detainees kept at the Srebrenica Police Station were cruelly treated and that one of them had been killed. The trial chamber therefore fails to understand how, notwithstanding the predicament he faced on a daily basis, the accused could, from that time onwards, safely assume that such incidents would not reoccur and that there was not even the need to at least seek to verify whether detainees were maltreated again. It is striking that the accused appears not to have taken any action regarding Serb detainees after Atif Kirdzic assumed command over the Srebrenica military police on 22nd November 1992. Rather, the accused, as already stated, repeated that because of the deteriorating military situation, the detention of prisoners was not on his mind, as there were others responsible for it. The trial chamber is convinced that had the accused at least made an effort, he would have been able to redistribute available resources to provide the required amount and quality of guards, if necessary also from his own fighters, to prevent reoccurrence of maltreatment. He could also ask for a report in whatever format. Between 22nd November 1992 and early January 1993, the accused was not always on the front line and found time to attend meetings in Srebrenica, at least until the Serb winter offensive started in late January or early February 1993. Yet, he did nothing of the sort. The conclusion that the trial chamber arrives at is that it was not impossibility that stood in the way of the accused in preventing the maltreatment and murder of prisoners.